Can the Second Amendment and modern America coexist? What was the original intent of the right to a regulated militia and the right of the people to keep and bear arms? How have Supreme Court decisions defined the Second Amendment? These are the questions we will answer in this podcast series called The Right to Bear Arms in Modern America. I am Harriet Taylor Wollstonecraft, with original content by R. Smith. Shall we begin? The original Constitution, which 39 state delegates signed on September 17, 1787, after a 4-month-long constitutional convention, made it clear that any newly formed federal government of the United States of America would have limited powers. While the original Constitution expressed the notion of limited power within the federal government, it provided few specific rights and liberties for the people. Without individual rights attached to the Constitution, many state delegates believed that a strong federal government could potentially abuse its citizens. These delegates, called Anti-Federalists, were led by Virginia's Patrick Henry, who did not sign the original Constitution and demanded a Bill of Rights for the people, refusing to support ratification of the document without amendments attached to it. Reluctantly, the Federalists, led by Virginia delegate James Madison, the father of the Constitution, being its primary writer, and New York delegate Alexander Hamilton, agreed to the amendments in order to complete ratification. The federal government of the United States under the U.S. Constitution began operation on March 4, 1789. And 6 months later, on September 25th of the same year, the first Congress adopted 12 amendments to the Constitution. In 1791, the states ratified 10 of those amendments. Sharing the Second Amendment, of the 10 original amendments, are two ideas that the framers of the Constitution constructed to align with one another, although the specific reason for the alignment is not altogether clear in the eyes of many. The ambiguity of their relationship to one another has created division in the years since ratification. Additionally, the American populace has tested both ideas as separate entities and as a single idea through the years because of the amendment's simple phrasing and lack of elaboration. Therefore, interpretations of the amendment are vast, far-reaching, and polarizing. And its place within the context of today's modern society adds to the complexity of the 27 words that make up Amendment 2, which reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." The U.S. Constitution is the world's longest surviving written charter of government. It is a miracle of invention. While the U.S. Constitution is brilliant, do all of its 18th century notions make sense in a modern world? Specifically, should the right to keep and bear arms apply to today's relentlessly violent society where mentally and emotionally disturbed individuals regularly make headlines by killing people in mass with high-powered, modernized weaponry? In an objective way, we explore the original application of the Second Amendment and how the United States courts have defined it through the years. Because of the age of the U.S. Constitution, it seems reasonable to test it. Consider that since its ratification, the U.S. has expanded by 37 states from the original 13, and the population of the nation has increased by more than 320 million citizens. In particular, the Second Amendment must wade through conscientious waters as the technology of weaponry has advanced considerably since the creation of the amendment, moving from muskets to machine guns. The Supreme Court has tested the interpretation of the Second Amendment on numerous occasions since the ratification of the Bill of Rights, but the first test didn't occur for nearly 90 years. In United States versus Cruikshank in 1875, which involved the use of a firearm, deemed illegal during the murder of more than 100 black men over a political dispute. The overall decision by the court was complex and convoluted, but one part of the decision was clear, which is that the Second Amendment does not prohibit state and municipal regulation of firearms. The court issued the following: the Second Amendment declares that it shall not be infringed, but this, as has been seen, means no more than that it shall not be infringed by Congress. This is one of the amendments that has no other effect than to restrict the powers of the national government. Furthermore, in Presser v. Illinois in 1886, the Supreme Court reiterated the stance found in United States v. Cruikshank by applying it to state regulation, stating the following: the provision in the Second Amendment to the Constitution that the right of the people to keep and bear arms shall not be infringed is a limitation only on the power of Congress and the national government, and not of the states. The case involved a citizen militia group that was associated with the Socialist Labor Party. Armed and on horseback, the militia paraded through Chicago in a show of force, before being indicted because they were not a part of the regular organized volunteer militia of the state of Illinois. Therefore, the Supreme Court also clarified notions involving a well-regulated militia by disposing of the argument that individuals have the right to assemble as a militia independent of state or federal authorization by issuing the following statement: it shall not be lawful for any body of men whatever, other than the regular organized volunteer militia of this state and the troops of the United States, to associate themselves together as a military company or organization, or to drill or parade with arms in any city or town of this state, without the license of the governor thereof. The ruling gave states significant power to establish laws outside of the Bill of Rights and made it clear that only state governments, aligned with or without the federal government, could organize and deploy militias, and that militias formed by ordinary citizens would not receive legal backing by the highest court. The third test of the Second Amendment occurred 8 years later, in 1894, in Miller v. Texas, an elaborate case developed involving the murder of a police officer with an unlicensed handgun. In the proceedings, Franklin Miller questioned the validity of a Texas gun restriction law, saying it violated the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." The addition of the 14th Amendment into the fold of individual rights, which Congress ratified in 1868, either further complicates the voice of the Second Amendment or clarifies its message by making it harder for states to regulate, restrict, or infringe upon gun ownership. However, in this case, regardless of the 14th Amendment, the Supreme Court again ruled that the Second Amendment did not apply to state laws, in this case, Texas laws. It was another 45 years before the Second Amendment was tested again, in United States v. Miller. In the 1939 case, the Supreme Court tied the Second Amendment's two ideas of militia and arms together for the first time in a dispute over the transportation of an unregistered sawed-off shotgun across state lines. This action violated the National Firearms Act of 1934, which regulated short-barreled rifles, machine guns, and silencers. The court ruled that the Second Amendment did not protect the charged man because his act did not assist in the cause of a state militia or the defense of the United States, stating the following: in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length, at this time, has some reasonable relationship to the preservation or efficiency of a well-regulated militia. We cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. To reiterate, in this case, the right to bear arms is tied directly to state organized militias and national defense. The decision also introduces the idea that the type of weapon can be considered when ruling cases involving the Second Amendment. Moving ahead 41 years to 1980, Lewis versus United States, a case with no direct link to the Second Amendment, discussed the merits of the Gun Control Act of 1968, as well as other laws that prohibited felons from owning a firearm. The Supreme Court said the following about gun control laws. These legislative restrictions on the use of firearms are neither based upon constitutionally suspect criteria, nor do they trench upon any constitutionally protected liberties. Afterwards, the court called upon statements found in United States v. Miller to conclude the court's point, saying that the Second Amendment guarantees no right to keep and bear a firearm that does not have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Next time, in Part 2 of The Right to Bear Arms in Modern America, the Supreme Court changes course, reversing ideas found in previous decisions, and we discuss the original intent of the Second Amendment as it was written. I am Harriet Taylor Wollstonecraft, with original content by R. Smith. Thanks for listening. Until next time, enjoy the moment. Harriet Taylor Wollstonecraft is the AI-generated voice of Christy Carlo. A professional communicator found at christycarlo.com. Consent to use Christy's AI-generated voice has been granted by purchase through Jenny by Lovo, a voice production platform.